So we'll start from the beginning, and we have two this thing. One is we'll discuss on RERA and then consumer code. So in particular, this thing, you have to give right advice to your clients that where they should go. They should go for RERA Act or they should go for the consumer, right? So the client, when they come to you, they depend on you for the right advice. So now we start. I think I'll share the screen. This RERA Act came, there were already laws. There were cases filed in City Civil Court, there were cases filed in the high courts, but people had to wait. The litigants had to wait for decades together to get a justice. So intent of this RERA legislation was to give consumer, the home buyer especially, a quick and affordable justice. The fees is 5,000 rupees for one complaint. But initially, if you had gone to, say, High Court, and if the property value was about 2 crore rupees, you have to deposit 3 lakh rupees as a court fee, which is never refundable. And it was an expensive affair, High Court fees. Then if you have to engage in counsel, then again counsel fees. So for a common man who has put his whole hard-earned money in buying a dream house, that was becoming a far rich. So the legislature made this RERA Act with a good intention. But nowadays we see that RERA is also not becoming that effective. And why the RERA Act came was the builder used to have one-sided agreement. The possession date was not mentioned. It was kept blank. And the area, they will say, this is built up, this is super built up. So you were getting 500 square feet flat, but they used to, charge you 900 square feet, 1,000 square feet. So that clarity was not there. So two things which RERA made into force and which is far beneficial to all the members, that we get a clear-cut possession date, because they have to, when they are uploading to register their project, they have to mention the date of possession. That is one thing. And mention the date of area. What is the carpet area as per RERA? So there are four carpet areas. One is the MOFA carpet, which is the net usable carpet, which the VMC calculates. And the RERA carpet is from wall to wall. So internal walls are not deducted as per MOFA Act. So you are losing 3 to 5%, but that is fine. See, if they say RERA carpet is 500, so you will be getting around 480 to 485 square feet. But initially, the builder, that same 500 was sold to you as super build-up area 1,000 square feet. So this has brought that transparency. And there was a one-sided builder-buyer agreements, no sector-specific regulator. Civil codes and consumer forums were slow and ineffective. But nowadays, I practice in both RERA and consumer code. So I find that consumer code is more effective than in RERA. We'll come to later that how and why we should go to NCDRC to save time, and how we should strategize our decision as per the client's requirement. And this is a special law. If when the RERA comes, you cannot approach any civil court, either city civil or high court. But you have an option. You can go to the RERA as well as the consumer court. RERA does not replace contracts. It disciplines them. See, it was enacted under currently 96 and 7 Central Act with state level authorities, uniform rights, localized procedure, judicial view. Parliament intended national uniformity with local execution. Now, still, all over the India, they have not finalized a template of how the buyer builder agreement should be. They are still in the process. One that is there, then they just have to fill with my plot number so and so, I'm giving so and so square feet at so and so floor, and it will be a balanced act. Now, one thing has also come, in force after the RERA, that before the builder, if you pay delay, builder used to charge you 18%, 24% of the delay. And when the builder was delayed, he was not paying you anything. But RERA says that if there is an delay by the builder, then he has to pay State Bank of India lending rate plus 2%. And even if the home buyer, who is called an allotee in the RERA, makes a delayed payment, he also has to pay the same interest rate as per State Bank of India lending rate plus 2%. So the interest rate is balanced for both of them. It is equal. No, neither the builder can charge you more or neither the home buyer can give less to the builder. So the interest part is very much clear. Acha, now the land owner, they are also come under the co-promoter definition. If even the society has given the development agreement to the builder, and if the builder fails, the society also comes under the co-promoter and society is also liable as per the latest judgment by NCDRC in Goregaon Pulse Society, where the builder failed to refund the money to the home buyer and the society had terminated the builder's agreement and they stepped into the shoes of the builder and completed the project, but they did not completed the sale component building. So when three buyers went to the NCDRC and then to the Supreme Court, the Supreme Court also said that now it is the responsibility of the society to pay to these three home buyers. So it was coming somewhere around 2-3 crores for each flat. So 9 crore rupees liability was there on the society. So if your society also is going for a redevelopment, you have to be very careful that you don't fall into such trap and the builder takes the money, he goes away, and then the home buyers comes after the society and you the building is not constructed, you are roofless, you are not able to pay the transit rent, and then there is a liability from the home buyer that since you have appointed the builder and you stand into the shoes of co-promoter, you refund our money. So this is a very two-sided sword. When you are going for a redevelopment, this clause has to be taken very carefully and you select a builder who is not a fly-by-night operator. Mere tenants or licensees standing on file complaint flows from this definition. Now, for filing a complaint in RERA, as an existing member of the society, you cannot file it until and unless you have purchase some additional area from the builder. Then the definition of LOT will come under you and you can file a complaint. Otherwise, tenants or subleasee, they are not the LOT and they cannot file a complaint under the RERA. Apartment plots, if there are more than 8 apartments, then the builder has to go for the registration of the project. Otherwise, if it is below 8 apartments, then there is no need of going into it. There are developers, who develop the plots with the driveway and all, and they sell the plots. So even if you are a buyer of that plot, come under the definition of RERA as an LOT. Net usable area with internal walls overrides this. We have already, I made you understand. Now this is a very good thing that if a builder wants to sell his project and advertise, so first thing he has to go to the RERA, upload all the documents, what he has obtained, the CC, and what is the date of possession, and all the details, the approved plan, then IOD, commencement certificate, everything has to be transparent. And then only he can advertise in the newspaper or hoarding or any type of advertisement is allowed if the project is registered with the RERA. Until and unless the project is not registered with the RERA, they cannot advertise. There are heavy penalties, but till date, I have not seen RERA penalizing any builder with heavy penalty. Now for the evidence is the RERA website. What you should do is you should download the RERA website. If you are interested in that project, you download whatever the details are there, save it, and then you can save the source that was downloaded from the RERA website. Because there they will have to give every details. Till then, the RERA website does not allow them to, do the advertisement. It will be stalled. Registration certificate will not be given to the builder that you have the registration number of the so-and-so project by RERA. So he has to do all the formalities, the chartered accountant, the architects, whatever is there, you should go to the RERA website and you'll come to know that all these details are to be seen by the home buyers transparently. So one thing is that transparency is there after RERA coming into force. Otherwise, they had no approvals and they used to sell and take the amount. They used to take it in cash, and then after you go there, then the plot belongs to someone else and the builder has taken the money and he's gone to Dubai or USA, you don't know which country, and then becomes very difficult to track them and bring them to India. But after this RERA, all that details are there with you, bank account details are there with you. So it's a in a way, it's a very good thing. Now, whatever amount they collect, 70% of the collection goes into the escrow account. 30% goes for them for their day-to-day work, paying salaries, maintain the office, to run the administrative work. 70% of the amount which they receive, they have to put it in the same project and do the construction. And there will be a certificate from the chartered accountant as well as an architect and engineer that he has completed so and so amount of work, so this much amount he can utilize. So this is a very good thing. Otherwise, what used to happen, now he buys a plot in Andheri, he starts advertising it, he takes the money, then another plot he gets in Goregaon, so he diverts that money from Andheri plot to the Goregaon plot. So neither the Andheri project is been completed, neither the Goregaon project is completed, and then he gets one more plot in Malad. He also starts taking booking there. And then you will see that the builders have a lavish wedding of their daughter or the son. And this money is spent because we are donating them. So you have to be careful. Now, RERA has taken this care that the builder cannot remove the money for any other purpose other than the construction of the same project. The CA certification is mandatory. Objective prevent fund diversion or core historical abuse. So decades together, this was, abused by the builders. So the RERA is trying to streamline it. Now, the revocation. This is also a very good thing under Section 7 and 8. If the project is revoked, then under Section 8 of RERA, you allottees can come together, form an association, and step into the shoes of builder and complete the project. So this has not been happening very often, but this also needs to be, looked into, that we step into if we have spent money and there is a stall project, our money is stuck. So who is going to construct it? So we as an home buyer form an association, step into the shoes of the builder. First, we go for the revocation of his registration. And then in the Section 8, we as a promoter complete the project. Now, the RERA says that they have to complete the project as per the deadlines, adhere to the sanction plan. Initially, what used to happen prior to RERA, the builder will show you one plan, then after some time he's getting some additional FSI, he will change the plan, he will change the layout of your flat, he will change the area of your flat. But if he wants to do that for some compelling reason, first he has to take the consent of the majority of the home buyers who have booked the flat. Till then, you cannot do anything. Now, you have seen that 33,000 buildings in Mumbai, they don't have OC, neither they have the conveyance. But the RERA has come out that the moment 51% of the flats or units are booked, I'm not saying that if they are registered sale agreement, are booked, then they have to form an association or a cooperative society. So this is a very good thing, but we should be aware of it, and we should ask. The moment we come on the RERA website, we'll come to know that he has sold so-and-so flat. The moment it crosses 51%, you write to the builder and a copy to the RERA that he is supposed to form an association or a society. So this is one of the best things which has happened in RERA. Now, any misleading representation, brochure and advertisement and a verbal assurance entities allottees to compensation. Now, any misleading, it can, while selling, we have seen, we have been fighting for many cases where they will show you that if they want to sell it to Jain, they will say Jain Bandir is going to come up here, and they will show you in the brochure also. Or if they want to sell to the affluent class, they will say there will be a jogging track, skywalk will be there. But when the project is completed, nothing is seen there. So any misleading representation. But in RERA, it has not happened so far. But I will show you one of the order from the RERA. See, this is recently passed order, that is 17th October 2025, right? If you see who are the complainant, the three, the husband, wife, and the mother. It is against whom? RERA Realtors, Omkar Realtors, and ICICI Home Finance. Now, why ICICI Home Finance? Our clients were also client of ICICI Bank. Then this ICICI Bank sent them an email that Omkar Altamont project is the luxurious project, and it will be completed by 2017 tentative date. Because the email had come from the ICICI Bank, our clients booked the flat. And now ICICI Bank said that, we are no way responsible. But as per the new Act, Consumer Court 1986 is repealed, and now Consumer Court Act is of 2019 and Rule 2020 clearly says any endorsement by anyone, it can be a film personality like Shah Rukh Khan or Akshay Kumar or anyone, if they are endorsing the project and if there is a failure, if there is a deficiency in service or the product is not good, even that person is also held responsible. See, the opposite party number 1, 2, and 3. 3 is whom? ICICI Bank Home. Jointly and severally directed to pay complainant rupees 1 lakh towards the compensation and rupees 25,000 as litigation cost. Now, why this is important for you is this can happen only in the consumer court. Although there is a provision in the RERA, but it is never any order has been passed in such a way. So when somebody is endorsing that project or somebody is advertising that project, and if there is a deficiency service or there is an unfair trade practice or there is a defective good, you can make that person who is endorsing that product as a party, and he also has to pay the cost or whatever the penalty or whatever the compensation is decided by the authority. So this is a very good thing which has happened in the Consumer Protection Act. That's why I'm giving you both the perspective of the RERA as well as the Consumer Court. Now, one more thing which RERA has brought has a positive effect is a builder cannot take more than 10% of the amount from you. If say the cost of that flat or that unit is 1 crore rupees. So on the allotment, he can take from you is up to 10 lakh rupees on an allotment letter. But the moment he is demanding 1 rupees above the 10 lakh rupees, he has to go for a bidder buyer registered agreement. Violation of this renders collection of illegal penalties from the builder. So this section 13 is very important. So if you are paying to the builder, so you insist that if it is more than 10%, please register my agreement. And this you can write to the RERA also and to the builder also that he is demanding, or you can make a formal complaint in the RERA that he is demanding more than 10%, but he is not ready to execute the registered agreement with me. So this is a very serious thing. Section 14. No unilateral changes. Consent of 2/3 allot is required. Promoters' autonomy is statutorily curtailed. Now, what was happening initially, while selling, they used to show you some plan, show you some layout of your flat, and give you that this is the area, 480, 500, 800, whatever it is. And the builder, without consulting you, without taking your consent, they used to change the layout, they used to change the area. So now, until and unless if the 2/3 allottees give a consent to the promoter, he cannot make any changes, even if the plan he has brought is a sanctioned plan from the BMC or MMRD or SRA. First, he has to take an approval and consent from the allottees. Then only, if the allottees agree, then only he is supposed to change the plan. Now, delay in possession. So these were the major issues that, there was, even after 15 years, the building was still not ready. Then there was a defective title. This section creates an indefeasible statutory right. As per section 18, there are two options available to you. If there is a delay of more than 6 months, then you have the right to take the refund of your money along with the interest. Or still, if you want to continue with the project, then he will have to give you interest for the delayed period till he gives you the possession along with the occupation certificate. So section 18 is the heart of the RERA, where the home buyer, the allottee, has the right to choose whether to withdraw from the project and take the interest for the amount which he has paid, or he continues in the project and gets the possession. And while taking the possession, he can, adjust the amount which is payable to the builder up as per the delayed portion or delayed period. If the project is delayed by 2 years, he can ask for the interest of the 2 years and plus the compensation. But compensation in RERA is high. It's around 50,000 to 1 lakh rupees or 1,25,000, not much more. So I already explained you two choices, refund plus interest or continue interest for delay, no need to prove loss. Agreement clauses cannot dilute judicial stance. Interest is not discretionary. So that the discretionary, now the interest rate is fixed for both the home buyer as well as the builder. That is State Bank of India lending rate plus 2%. As on today, it is 8.5%, right? So if you add 2% more, so it becomes 10.5. And if the project is delayed for 1 year, so you will get the interest of 1 year. It is that simple. So now section 19 of the RERA says the information, possession, conveyance, timely payment, compliance with agreement, everything there is in section 19 is for the home buyer. What is the home buyer? That they have to make a timely payment and compliance with the agreement. If the home buyer pays a delayed payment, delayed installment, he has to pay the interest to the builder as per the agreed terms, that is as per the RERA, that is State Bank of India lending rate plus 2%. So this is a very good thing which has happened after the RERA. And then under section 31, you can, individual LOT can file a complaint or association, form an association, and the association will file on behalf of everyone, right? So representative complaints are maintainable. Adjudicating officer decides the compensation, district judge rank, district from authority. Summary trial, but it is sort of judicial. Natural justice applies. Evidence mostly documentary. Speed is equal to arbitrariness. Continuing costs of doctrine, delay causes treated liberally. RERA prioritize substantive justice. Now, suppose now what happens? You get the order. Now the builders have become very smart. What they will do is they will go for the review. Why review? Because in review they don't have to deposit anything. If they want to challenge that order, they have to go to the appeal. In the appeal, they have to deposit 50% to 100% depending upon the member's discretionary power. Now, what happens? They will, after the review is over, they will go to the appeal. In appeal, in the Roznama, they will find some silly mistakes. And if the comma or full stop is not there, they will interpret that sentence in a particular way. And then again, they will go to the High Court. So I am also facing the same problem for my two flats. The order was given for the possession or refund the money in 2019. But till today, I am struggling at the execution level. It went into appeal. Then it has now in the execution, I had two flats in the name of my mother. Instead of two flats, they have, changed the number and made it to one flat. So now what has happened is I have to go to the review. I have still the procedure is there in the review that my complaint was for the two flats and not the one flat. So in the operative part of the order, they missed out one flat. So these things are happening. And since 2019, you calculate today is 2050, 25. Still 6 years, I am being struggling. So the RERA orders are not taken seriously by the builders. That is the one fact which I will also admit it. I will not say, although the act is good, but when it comes to compliance, it is, like in the first gear. What we need is a turbo boost of the implementation of the order, which is not happening in RERA. So now once the execution order is there, then the district collector will attach the property and bank accounts of that builder. So you can file an appeal under section 43 of MahaRERA Act, that is called appellate tribunal. Now, if the builder wants to file an appeal against the order, there is a mandatory pre-deposit for promoter. No automatic stay will be granted. But promoters, they have various ways of dealing with this type of things and they delay and nothing happens. If you go to the collector says, now it is the election time, I don't have staff. Then he will say, I have sent it to the Tehsildar. You go and contact with the Tehsildar. Tehsildar say, I have so many other works to do. I don't have time. And the bank account is not proper or the address of the property is not proper. So you get that order again rectified and bring it to me. So this is all the delay tactics which happens in the RERA. Then after the appeal, then the second appeal, he can go to the High Court also. As I told you earlier, civil courts are barred. There is a writ jurisdiction survives. Under Section 79, nobody can go to the civil court. Then Section 80 and 89, RERA is additional to the other laws, overrides inconsistent provisions. Buyer has choice, no double recovery, strategic forum selection crucial. So now we have almost done with the RERA. Now we'll go with the consumer court. Before we go to the consumer court, I would like to share something very important. Now there is a circular which everybody should know about the MahaRERA is of 3rd June 2022. Right? What does it says? See, if you want the refund of your money, if you go there and the sales team makes you so much, entice you so much that you are impulsive, you book the flat. Then when you come home, you talk to your family members and your friends, and they advise you that this project is not good, or this builder is not good, or the project is very far from the railway station, or very far from the bus stop, or there is no transport facility available, and you decide that you want to withdraw from this project. So if you apply within 15 days, they have to refund you with complete amount without any deduction. But you apply from 16 to 38 days, they will deduct 1% of the cost of the said unit. Now just imagine, now you have booked a unit, whether it is a shop or a flat, which is of 1 crore rupees. And you are given a 5 lakh rupees as a token amount. Now, how much they will deduct from that 5 lakh rupees? 1 lakh. So you will get the refund of 4 lakhs. If you deduct within 31 days to 60 days, they will deduct 1.5%. And from 61 days from the issuance of the allotment letter, they will deduct 2%. So if you are given a deposit of 5 lakh rupees, 2 lakh rupees will be deducted, and they will refund you 3 lakh rupees. That also after a very long time. So this circular is, according to me, is unconstitutional because it is not passed by the parliament. It is the RERA who has passed it. So sooner or later, someday, someone will stand up and will challenge this arbitrary clause or the circular issued by the MahaRERA. So this is a very important thing that, the MahaRERA has come out, and instead the intent of the RERA was to protect the interest of the home buyers. But here it is, indirectly giving benefit to the builder. Now there is one more order, a circular. This circular says, so now this was, from March, April, May are extended up to 30th June. Now builder and even the MahaRERA, it is never said that the interest for this period has to be waived off to be given to the home buyer. But they definitely write in the order that the builder can take the benefit of this moratorium period. And this period is extended till 1 more year after another circular. But I will tell you, there is now we come to one more order. Kindly see what it is. 25th August 2023 through video conferencing. I'll just read the relevant part to make you understand why I prefer consumer code rather than RERA. See now what this says, point G, with regard to the payment of interest to the complainants, the MahaRERA further directs the respondent promoter entitled to claim the benefit of the moratorium period as mentioned in the notification order number 13, order number 14, dated 2nd April 2020 and 18th May 2020, issued by the MahaRERA, and the notification order which may be issued in this regard from time to time. Here, what he's saying while paying the interest to the home buyer, you can take the benefit. This is order is of 23rd August. And now we come to another order which was passed in the month of July, right? Where the point D says, promoter is not entitled to benefit of moratorium for the purpose of calculating time period for interest liabilities under Section 18 of the Act is pursuant to the notification order number 13 and 14 dated 2nd April, 18th May, issued by MahaRERA. Now, this was pronounced in the month of July. The next of the order which I have showed you before is announced in 23rd August. So now just understand that the MahaRERA presiding officer are not taking the cognizance of the order passed by the higher authority, that is appellate tribunal, which clearly says, see, this is passed in 14 June, where it clearly says, point number D, that no benefit of interest is to be given to the builder. He has to pay the interest. Now, if you see this order that is granting the permission is of 23rd August, and this order is of 17th July, 1 month prior to this order. So these are the lacunas in RERA. So somebody will have to file a public interest litigation that RERA is not following the order passed by the appellate tribunal, higher authority. Now, what happens? Why I'm bringing you in front of this is that in MahaRERA such type of things happen. So why I prefer a consumer court is that if you go to the consumer court, as I showed you before, that even the ICICI Bank who sent an email, endorse a project, was also penalized. If you want to go to the consumer court, make you understand the crux of the consumer court. Now, if you're paid consideration, I'm forcing on the word paid consideration. If your value of that unit is, say, 1 crore rupees, but you have paid only 49 lakh rupees, just below the 50 lakh rupees, then you have to file your complaint in district forum, that is at Bandra for Mumbai. If you have paid about 50 lakh rupees, that is 50 lakhs and between 2 crore rupees, your remedy lies in state commission, that is at Kalakoda. But if you have paid 2 crore rupees, then you can directly go to the NCDRC, because we have heard that, the RERA is been not LOT friendly or not consumer friendly. So what we have worked out is we make all the people, all the LOTs come together and form an association, and we see that all the members who are coming together to the association, their paid consideration in total is about 2 crore rupees. So that we can directly file the complaint in NCDRC. Now, what are the benefits of filing a complaint in NCDRC? Filing a complaint in NCDRC means this is the second last stop. After that, only one remedy is available, that is the apex court, Supreme Court. So anyone who is aggrieved either by the LOT or the builder has only one option left, that is the Supreme Court. And Supreme Court decides this matter in a very short time. Whatever I have seen 99% of the orders passed by the NCDRC are upheld by the Supreme Court. So this is the beauty of approaching the Supreme Court, because if your consideration value is below 50 lakhs and then you file a complaint in consumer court, then it takes a long time. After district commission, it will go to state commission. From state commission, it will go to NCDRC, and from NCDRC, it will go to Supreme Court. But all of you come together and cross the threshold of 2 crore rupees, then you can file a complaint in NCDRC, and within 3.5 years, you will get the order, depending upon how many holidays are there and all the dates. The judges are also present, and after that, whoever wants to challenge that order has to go to the Supreme Court. Now, in RERA, what happens? 6 years are wasted here. Now, suppose if my execution order is also now in favor of me, he doesn't comply, he will go to the High Court for the second appeal, because first appeal is already over. Then again in the High Court, I'll have to spend my time 5 to 10 years. So the total litigation span of as an advocate, my flat on my mother's name is going to get after 16 years. So why wait till long? You can easily go to the NCDRC, file a complaint there, and once the order is there, whoever is agreed, either the builder or the LOT, you have only one option, that is to go to the Supreme Court. So this is the beauty of NCDRC or going to the Consumer Court. The Consumer Act, there was initially it started in 1986, which was repealed. And the new act has come into force in 2019 and 2020 is the rules. Now, what do you think the Consumer Act is only dealing with the home buyers or any other thing? Consumer Act only deals with all consumption. Yes, Consumer Act applies to all the goods and services. Shreya Pandey, good answer, yes. Knows good and services. Now, can you define, now suppose I tell you, there is one more area in consumer court that is called medical negligence. So I have argued one more case in medical negligence where a lady has lost her eye after the cataract operation. Yesterday only I came to know that order is been signed by the authority, but I don't know whether it is in my favor or not. But anyways, I am going to share that order. I'll make a short video because we have done a lot of research. My team has also done a lot of put a lot of time and effort, to argue this matter. So there is, when you see that if there is a medical negligence and if you have the evidence, and then if you have an expert opinion on that, then the chances of winning that case is very fine. That is one thing. Then whatever you buy on Amazon or Flipkart, if there is a deficiency in service or unfair trade practice, you can definitely file a complaint. Whether they are based in Singapore or anywhere, you can still file a complaint here in Consumer Court. Then for the traveling, if you have booked the ticket and the plane has been delayed for more than 2 to 3 hours, you can still file a complaint in the Consumer Court for their deficiency in service. So there are many aspects in this consumer. It is not only dealing with the delayed possession of the home buyers. This is a very good question here, that for filing consumer complaint against the builder, the jurisdiction should be Office of Builder, or now I'll tell you, if your paid consideration is about 2 crore rupees, then your jurisdiction is there in the Delhi, in NCDRC. So it doesn't matter whether builder stays in Mumbai or whether builder stays in Bangalore or Goa. You will lie your remedy jurisdiction as per NCDRC. See, there are on the books, I tell you, the RERA Act is wonderful. It looks very strong on the paper. But if you ask me the implementation, it is in the first gear. It's not going in the top gear. So what we need, RERA has to come out with the compliance of the order in a turbo boost speed. From the date of default where the builder he promises that he will give the possession in, say, December 2023. The moment he is not able to give the possession, the clock start ticking from that date, from the date of default of giving the possession.
Hello, sir. Can you hear me? Hello.
Yeah, I can hear you. Yes, go ahead.
Yeah, my question is for the builder to I'm going for the redevelopment and my land is 10,000 square feet, but I have read that 1,500 square meter. If there is a 1,500 square meter is there, then only the builder will registered with RERA. Otherwise, no. Is that my correct?
No, it's wrong.
Yeah. Then even the even 10,000 square feet is he needs to register with RERA.
Yeah, he needs to register with RERA, but you ask about your interest. Your interest as an existing member it's not been taken care by the RERA.
No, he will additional flat also he will build, no? Means for redevelopment we are
Additional
going.
flat build, the home buyer who is building, who has a remedy under RERA. You don't have a remedy under RERA. As an existing member of the cooperative society, you don't have any remedy under RERA.
सर ये 2/3 कंसेंट जो परमिशन है वो तो वो बिल्डर पोजेशन होल्ड कर देगा तो वो ऑटोमेटिकली एलओटीज को देना ही पड़ता है मतलब कोई भी वो चेंजेस करता है मान लो तो वो चाहे वो एलओटीज के फेवर में है या नहीं है इवन तो वो देना ही पड़ेगा उन्हें। और बीबीए भी जो वो है वो अपने हिसाब से बनाता है। अभी रेरा की कोई इस गाइडलाइंस है क्या सबका जो बीबीए है वो एक सेम फॉर्मेट में रेडी कर रहे हैं बिल्डर्स मतलब इन लाइन ऑफ द गाइडलाइंस ऑफ द रेरा?
See, builder buyer agreement, he has to upload on the RERA website. Are you aware of that?
नो सर, नो सर।
If you go to his registration number, you will get a template of allotment letter. You will get the template of builder buyer agreement, which you have to download and get an opinion from your advocate. You have to pay him some fees, and he will say whether these clauses are aligned with you or not. If they are
नहीं नहीं
not,
सर
then you
मतलब रेरा अथॉरिटी को वो करना चाहिए ना कि उसको एक फिक्स फॉर्मेट बनाना चाहिए सो दैट कि
sir,
बैलेंस देयर शुड बी
it is there, but still also builder will play. Why they will play? Because they know that nobody reads the agreement. They just sign on the dotted line. So they know your psychology and they take undue advantage of that. So you have to point out if there is something you find it is not perfect, or there is some ambiguity, or there is some any discrepancies there. You file a complaint in the RERA.
बट सर देयर शुड बी सम गाइडलाइंस फ्रॉम द रेरा ना कि नो बिल्डर कैन
Sir,
यू नो
have you gone to the
डाइवर्ट।
RERA website?
Sir, every state have their different website. I'm from Haryana, so I have gone through the Haryana website,
Yeah.
Haryana RERA website.
Mhm. So it is
And
there.
sir,
And suppose if it is not there, what is stopping you to do your due diligence before parting with the money? You have to
no,
always
but,
take an advice.
no, what is the meaning of RERA then? The RERA should have controlling
That's
authority.
what I told
So
you. That's what I told you, that I prefer consumer court rather than RERA. Here, I'm not promoting RERA here. I have
yes, sir,
just,
yes, sir.
yeah, I have brought out what are the shortcomings of RERA in my presentation.
And sir, if we have already filed a complaint before the RERA authority, and can
Hmm.
we file compensation application before the executive officer before order of the authority, or we need to wait for the order of the authority before filing our compensation application?
No, then in that case, you have to file a two complaint. For the compensation, you filed with the adjudicating officer, and for the regular, you file a regular complaint.
And sir, if we have already filed the application before the authority, then can we file our compensation application before the consumer forum?
I don't think it's a good idea. It is always better, and what is preferred by me is that you go to the consumer court. If your paid consideration is say below 50 lakh rupees, 4 to 5 people come together, make a threshold of 2 crore rupees, and then you file a complaint in NCDRC.
No, matlab in case we have already filed the application before the RERA authority, can
That's
later
what
on.
I told you. It's not a good idea now that you one complaint you file in RERA, and then for compensation you file in consumer court. I'll have to go through your documents, and then only I can tell you, decide if the same prayers are there, then it will become a res judicata, and both the complaints will be dismissed.
Okay, sir. Okay, sir.
So
Thank you,
if
sir.
you are not prayed here that particular thing, then you can suppose if there is a defect liability for the 5 years, he has to maintain it. So after taking possession, also you can file that these things were not provided, and then you can go to the consumer court. So it will. I'll
Okay,
have to
sir.
go
Thank you.
through what are the contents of your complaint before I comment anything on it.
Sir, Yogesh sir in the chat box is asking Rajesh sir's question, follow up to that. So then the tenants are protected under which law, under which authority in case of redevelopment?
They will have to file a complaint in consumer court. You will have to first take a valuation report from the government valuer that at the time of giving my flat for the redevelopment, my value of the property was so and so. Once the valuation is decided, then we can decide the pecuniary jurisdiction. Again, I will say that instead of going single, come together, make a threshold, cross the threshold of 2 crores and file the complaint in NCDRC.
Okay, sir.
Sir, I have got two societies with me. One society is not confident whether the builder will be doing the completion of the project, because only the MOU has been signed right now and DAPA is yet to happen. बट दे आर नॉट अवेयर कि अभी आगे वो स्टकअप हो जाएगा या कंप्लीट हो पाएगा. और दूसरा सोसाइटी जो है उन्होंने भी एमओयू किया है, लेकिन वो आगे बात बढ़ ही नहीं रहा है. वो हर बार कुछ ना कुछ नया रीजन लेके आता है बिल्डर और बोलता है कि अभी ये करना है वो करना है. एंड दिस हैज बीन इन द फर्स्ट केस, इट इज ऑलरेडी एमओयू साइन होके उसका जो पीरियड था वो भी एक्सपायर हो गया है. तो अभी
And
उस केस में क्या करना चाहिए
terminate that MOU.
सर? लेकिन फिर वो अगेंस्ट अगर सिविल में या कहीं पे डाल देगा अंडर कॉन्ट्रैक्ट एक्ट, तो फिर वो तो लंबा खींच जाएगा, क्योंकि ऑलरेडी 12 साल हो गए वो लोग बातचीत कर रहे हैं,
सर
लेकिन वो आगे बढ़ नहीं
12
रहे.
साल हो गए MOU साइन करके, अभी तक कुछ नहीं हुआ, तो इससे लंबा और क्या खींचेगा वो? सो दैट
बट
मीन्स ही डजंट हैव द कैपेसिटी. मेरी बात सुनो, अगर आज कल भी वो आता है, बोलता है ठीक है मैं काम चालू करता हूँ, आपको PLEA बना के वो खाली कर दिया, बिल्डिंग तोड़ दिया, और फिर बाद में फिर 12 साल रुकेगा, तो आप क्या करोगे? सो
करेक्ट
दिस
सर.
इज एन आई ओपनर दैट यू शुड यूज योर ड्यू डिलिजेंस.
सर
You
बट
should
वो
not be emotionally attached to the builder.
नहीं, वो एग्जिट क्लॉज नहीं है उस पर्टिकुलर एमओयू में.
हाँ, तो
वो
क्या
तो
हो
कुछ
गया? तो दैट इज अ वन साइडेड MOU बनाया है. दैट इज नॉट अलाउड ना. एग्जिट क्लॉज तो दोनों के लिए रहना चाहिए, फॉर द बिल्डर ऑल्सो एंड फॉर द सोसाइटी ऑल्सो.
सो फिर वो सिविल में जाएगा, उसके लिए जा सकता है
सर
मतलब.
सर अभी मैं आपने जो बोला उसका मैंने जवाब दिया. अगर डिटेल में जाना है, तो
हाँ.
आपका मेरे को MOU स्टडी करना पड़ेगा. 12 साल पहले जो आपने बनाया 2012 में, उसको स्टडी करना पड़ेगा. उसके बाद में उसकी स्ट्रेटेजी बनानी पड़ेगी कि हाउ टू गेट रीड ऑफ दैट बिल्डर.
Thank you, sir. And there is a second case which I discussed. The things are not moving. तो उस केस में भी यही एप्लीकेबल होगा?
सर मेरे को ये बताओ, सेकंड केस में भी वही हो रहा है, तो क्या आपने बिल्डर से शादी की है कि डाइवोर्स देने में तकलीफ होगी? नहीं ना.
नहीं नहीं.
यू हैव टू यूज योर लॉजिकल माइंड कि अगर ये 12 साल 10 साल लगाने के बाद भी कुछ नहीं करता है, तो व्हाई आई एम स्टक टू दिस बिल्डर? चेंज द बिल्डर.
ठीक है सर, थैंक यू.
सोसाइटी जनरल बॉडी मीटिंग में बुला के एक रेजोल्यूशन पास करे कि भाई 12 साल हो गया, इज नॉट मूविंग फर्दर, सो वी शुड टर्मिनेट दिस एग्रीमेंट और टर्मिनेट द MOU. और MOU क्या रजिस्टर्ड है? क्या नहीं है ना.
वो
नॉट
नोटरी
रजिस्टर्ड. हाँ, तो नोटरी क्या हुआ? MOU that won't stand long in the court of law.
Thank you, Amol sir. Sir, Hemant sir is asking, from when is interest payable in case of withdrawal due to delay by the builder?
If you are withdrawing from the date of payment which you have made.
And so Gopal sir is asking, in case a builder is under bankruptcy proceedings, so what is the builder status before RERA?
They come and say that it is under moratorium period, but it depends upon case to case. I'll have to go through, because I have recently gone through one judgment where the Supreme Court says nothing doing. You can still carry out your hearing in RERA and Consumer Court. So I'll have to, if what is the procedure which has been followed in the NCLT and all that, I'll have to see the documents first if they want to take any action. Even we can file an intervening application, interim application in the NCLT also.
So certain developers take a EOI, expression of interest, before the launch of the project. Now, is that valid?
Expression of interest.
Yeah,
Who is giving to
with
whom?
a token amount, with some money which may be bankable, which may not be bankable. But
No,
actually,
but
that's a marketing of the project before the.
No. Who is giving the expression of interest?
The
Builder
developer
is giving to the society.
Yeah. No, so the developer before launch of the project takes interest from prospective buyers.
It is not legally binding, because he can only sell his units, whether it is flat, shop, duplex, anything, or plot, only after getting the registration of the RERA. So whatever you have done before that, whatever under expression of interest and he has taken the money, that is very difficult to prove when the builder raises his hand or the project gets stalled. You are left with nothing. So why you want to take a risk? There are so many opportunities available in the market now. So go for where there is no risk, where everything is transparent. This is not a transparent thing. When he's not got the registration, still you want to continue. That means you are somewhere not using your logical mind.
So pre-launch such registrations can be intimated to the MahaRERA about violations?
Yes, you can.
Okay, because the consumer gets a good deal, but nevertheless, though it's a win-win, but
Sir, it's not never a good deal from the builder. He's trapping you. That is a sweet trap.
okay. Second question, sir. As you said, ICSI Home Finance was also a party as a broker, probably, right? As a real estate broker or whoever
As then
endorsed it.
they endorse the project. Yes, you're right.
Endorsed.
Endorse the project. Yes.
So it could be any model or influencer also who endorses a real estate project.
100%. If I tell you, if the Shah Rukh Khan is also endorsing some product or some project,
Wow.
and if it is not timely project, you can sue him also in the consumer court.
So one question in the chat box: does the district forum have the right to grant possession in case one party with a notarized sale deed has the possession? So can the district forum grant possession to the party having registered sale deed?
No. This question, I'll have to see their agreements. If the district forum grants a possession, but if the possession is already been given, so on what basis that possession is given? And which agreement is executed later or which agreement is executed first? So all that things have to be taken into consideration before giving any opinion.
Sir, I have one matter. In that case, the buyer has booked a flat for 30 lakh rupees, but he has only paid the half of the amount, that is 14 lakh, because the possession was not delivered on time. Actually, I checked the RERA website. In that website, sir, it was showing that it is under QPR. Okay. So, I just want to ask, due to non-compliance of the QPR, it was showing. So while I was searching, the project detail was not showing. But in this, there was a separate this building for every separate this tower. They have given the RERA number. I have paid only the half of the amount, sir. So in that case, I want to withdraw from the project. So actually, I have the possession date was 2024 September, but and he has taken the extension of 1 year on the RERA website. But I have sent the legal notice once the possession date was over, that is 2024. So here I didn't file the complaint before the RERA. So now can I file the complaint?
Yes, how many of people like you are there with you with the same sort of complaint?
There are around 5 people, sir.
5 people. So if you 5 people come together, then it will go beyond 50 lakh rupees. So come together and file a complaint in State Commission. If more
Okay,
people
sir.
are coming and if you cross the threshold of 2 crores, then file the complaint in NCDRC.
Okay, great, sir. So I
Instead
can
of
go to
going to RERA.
consumer court also,
It's
sir.
always better to go to the consumer court, come all together, cross the limit of 50 lakhs to go to State Commission, and if you can gather more people and cross the limit of 2 crores, then we can file a complaint in NCDRC Delhi.
Yeah, so my question was regarding, sir, there is a property which is in Raigad district, but builder office is in Thane district, and builder has delayed the possession. So where should I file the consumer complaint, or where should I go to consumer forum in Thane, or should I go to RERA? Because the location of flat is in Raigad district. So by that logic, I have to go to Alibag. So what is best?
Yeah.
You said, or how is
No, what I would suggest is instead of going to district forum, how many of you are agreed with the same this thing?
Sir, as of now, only one.
Then you have no option. Then go to the Alibag district forum. Or if you can come together, cross the threshold of 50 lakh rupees, you can file in State Commission, Kalagoda, Mumbai. And if you cross 2 crores, you can file a complaint in NCDRC.
So you would suggest that if 2-3 allottees come together, then we can go to State Commission.
See, above 50 lakhs and
Yes.
below 2 crores, you go to State Commission.
Yes.
Above 2 crores, you go to NCDRC.
Because my question is on technical basis, like if the office of builder is in Thane district and I paid money in Thane
Wherever
district,
it is, if you cross 50 lakh rupees, then only Remedies, State Commission. And if you cross 2 crores, the only jurisdiction is in Delhi NCDRC.
Yeah,
It
that
doesn't
I
matter
got, sir.
where the builder's office is.
No, that I got, sir. But if
Yeah.
builder's office is in
If you are
Thane,
going for the
can
district,
I
then
can
the
I file in
territorial
Thane?
jurisdiction will come.
Can I file in Thane District Consumer Forum as the
You
office chief?
can say that I'm working here or I'm staying here and it's difficult for me to
Yes.
go to Alibag. And if you can show sufficient evidence, then you can file in Thane also.
Okay. So on that basis, they will not reject my complaint or
No,
consumer
no.
complaint.
You give an
Thank you.
evidence why I'm filing in Thane. Because I'm working in
Right.
Thane, it is more convenient, or I'm staying in Thane, it is more convenient. The project may be in Alibag.
Sir, I have a question.
Yeah.
Regarding the same strategy which you suggested, bring more consumers and scale up the forum. So, what should be the prayer? Means I have 5 allottees who have booked units in a project against same builder, and the claim amount and the booking amount is around 5 to 6 lakhs for each. So, including the interest and compensation, I might have a chance before state commission. So what should
No.
be?
I'll make it clear. The paid consideration paid to the builder without anything. No interest, no compensation is counted. Only the direct money which goes to the builder's account, not even the stamp duty and this thing, registration. To file a complaint, it has to be a not net paid consideration paid to the builder.
Sir, because while filing e-complaint on Jagriti, they have 2 options, that paid consideration and claim amount. So the paid consideration must be about 50 lakhs. That's what you're suggesting.
If you want to go file a complaint to the state commission.
Yes.
But claim amount never decides your pecuniary jurisdiction. You may claim 2 crore rupees, but if, after hearing you may get only 20,000 or 2 lakh rupees. So that is the discretionary power of the bench to decide, right? They have made it very simple. The paid consideration paid for the goods and services, or the paid consideration paid to the builder.
Okay, sir. Sir, I have another question. In similar situation where my clients want to file consumer case and RERA simultaneously, and even I am on the point that the consumer. No, I'm just asking if.
No, it is not possible. I will tell you, either you file in RERA or consumer court. You cannot file in both.
So, basic steps to initiate RERA practice.
You are an advocate.
Yes, sir.
So, in which area you want to practice?
RERA.
RERA. So go to the RERA website, keep on reading the orders which have been in.
Okay.
And then you will get the idea about the RERA, what language the judges use to write the orders.
Okay.
And where do you stay?
Santa Cruz.
It's a good area. So many buildings are coming up. You'll have a good business in the summer.
And it's more of representing the consumer than the developers.
You are practicing in consumer?
No, sir. I'm asking you, sir. It will be more of representation of the consumers than the developers.
But if one builder is there, he's having 3 projects, 4 projects, 5 projects. But if you calculate, he will be, making 500 units to 1,000 units. The chances of getting aggrieved home buyers is good rather than going to the builders.
Okay. Any book that could be more insightful for this? Other than whatever you suggested, of course, I have to go through that.
There are no such books, but keep on reading the articles on the aggrieved home buyers in consumer court also, in RERA also.
Yes, sir. My question is, sir, my stage of RERA case is at written argument. So what written argument precaution should I take? Because I need to submit within 1 month.
What precaution you will take while submitting the written arguments?
Yeah, for the complaint is for not doing conveyance.
So it all depends upon what you have filed in your complaint and what you have filed in affidavit of evidence.
Yes, sir.
The same points we'll have to take, because you cannot add any new evidence or new things into the written argument. So whatever is there, you have to make the best of that.
Sir, can we wrap up?
No problem. Yeah.
Okay. Thank you so much, sir, for sharing your expertise and
we should.
experiences, and always helping our participants get clarity. Thank you so much, sir.
Okay. And thank you all
Thank
for
you, sir.
listening to me for so long.
Thanks, sir, for patiently addressing all the queries. The Q&A went for too long. Bye, sir. Thank you so
Bye.
much.
Bye.